Good evening, professionals. Today we are going to talk about the recent update in Companies Act, Companies Amendment Act 2019. This bill, which was passed by Lok Sabha on 25th July 2019, placed and proposed and passed on 26th July, and thereafter placed in Rajya Sabha on 30th July 2019, and received the accent from President on 31st July 2019. And today we have Companies Amendment Act 2019. After promulgation of Companies Ordinance 2018, which was promulgated initially on 2nd November, and to keep it live, it was again re-promulgated on 12 January 2019, and slight modifications made by virtue of Companies Second Amendment Ordinance 2019. And thereafter, after receiving the President's accent, we have the Companies Amendment Act with slight modifications made, and the ordinance bill is accepted as is. My sincere thanks to Mr. Sundarajan of our DVS research team for making this detailed and comprehensive presentation covering almost all the amendments in the Companies Amendment Act 2019. This is the structure of today's presentation. The interpretations, wherever it is applied in the future slides. Let's first understand why we have this Companies Amendment Act 2019. Primarily for restructuring of corporate offences. So all the criminal jurisdiction which were under the judicature of any other authority is now shifted to civil liability. Out of 81 offences, 16 such offences are shifted from criminal to civil liability. And then more to declog the NCLT jurisdiction. Some of the provisions are shifted merely because of being routine in nature from NCLT to the adjudicating authority. As we discussed, the recategorization of offences on certain provisions, primarily to provide relief to companies and to strengthen the ease of doing business. And CSR compliance norms have been streamlined and strengthened, and there is a shift from the disclosure. You either comply or make a disclosure to comply, and if you don't comply, you will incur severe penalty, and hence the CSR norms are strengthened and further tightened in the Companies Amendment Act 2019. So with this brief background, we will move on to the detailed classification of amendments. So first, we will see how the amendments are by the nature of the amendment proposed and the sections in the existing Companies Act 2013, sections covered in the new Companies Amendment Act. New Act is Companies Amendment Act 2019, and effective date from when we have this implementation. Declogging NCLT, section 2, subsection 41, which talks about the change in the financial year of companies holding subsidiary or associate company, which are primarily having an associate with a foreign company, by virtue of which, on account of consolidation of financial statement, they have this conversion of financial year. Section 14, where it is a conversion of public to private company, and hence seeking amendment to the Articles of Association to have the necessary clauses in place. And section 441. So all these sections are now moved from NCLT to the respective adjudicating authority. The sections covered in the new act are section 2, 5 and 39 to the respective sections in the Companies Amendment Act 2013. Then we have recategorization of offences. Section 53, issue of shares at discount. Section 64 for alteration of share capital. 92 for annual return, 102 for statement and to be annexed to your notice of general meeting, 105 for proxy, 117 for resolutions to be filed with the registrar, 121 for listed public companies to file the necessary annual report, 137 for financial statements, 140 for auditor's resignation. So all these sections which will be now moved to the from the offences are generally recategorized. So we'll be dealing with each and every section separately in the future slides. So the respective sections in the new act are covered in the third column, and this relevant change is effective 2nd November 2018, friends, the date when we had the Companies Ordinance 2018 in place. Then the CSR compliance, section 135, where the norms are further tightened to all the applicable companies, which is yet to be notified. Significant beneficial owners, section 90, where we had a lot of circulars and notifications from MCA for the BEN form, which was recently notified. So again, the effective date for the section 90 amendment is to be notified. NFRA provisions 132, we have further subsections being introduced and few other subsections being substituted, which we'll be seeing elaborately. This section is yet to be notified. PAS is prospectus and allotment of securities, where there is a shift from registration to merely filing, so which we will be seeing in the respective slide. Investigation by Serious Fraud Investigation Office, section 212. Again, there are amendments to the existing section in place, yet to be notified. Registration of charges, very interesting. So the timeline 300 days is now squeezed and we have only 60 days. So what will happen after 60 days? We'll be seeing in the respective slide. Disqualification of director, section 164, where by virtue of exceeding your directorship limit, you will be disqualified. This will be over and above all other disqualifications scenarios specified under section 164. Powers of registrar, section 10A, 12, 248, more for dealing with all the shell companies, to weed out the shell companies, verification of registered office, all these, and the powers widened to registrar to strike off such companies, which is why we had the active companies tagging identity INC 22A form also. Prevention of oppression and mismanagement, already we have this section 241, and what are the amendments or substitutions made in the respective provisions we'll be seeing in detail, and miscellaneous provisions are well covered in the respective slide. So declogging NCLT, we just saw in the first slide. So a company which is a holding or subsidiary or associate company, more because of a company incorporated outside India, they are consolidating their accounts and hence they have adopted a different financial year. In such case, on obtaining approval from central government, they can change the financial year. Previously, this was NCLT power. Likewise, this conversion of public to private company, which shall be valid only if such approval is obtained from NCLT, is now shifted to central government on making such application. Section 441, where compounding of offences, not being offences punishable with imprisonment only or both with imprisonment and fine. So in all other offences, there is a enhancement proposed from 5 lakhs to 25 lakhs, where it can be compounded by RD and the application need not be filed with NCLT. So if you read the footnote, it clearly says that any application which is pending before NCLT on the commencement of this new act, the effective date which we saw, 2nd November 2018, shall be disposed of by NCLT. So the transition provisions are clearly provided in the respective section. So this recategorization of offences, I'll not be dealing with these 3 slides in detail because it is more to do with the numbers, but here it is clearly classified as to what was the old provision and what is the new amendment. So for ease of reference and comparison, we can see that whatever was the fine imposed earlier, it has now become penalty. So friends, please remember what is the difference between fine and penalty. So wherever there is a fine, again, it will have an impact on the adjudicating authority to impose such fine over and above your fees or additional fees as may prescribe. But when it comes to penalty, the registrar can impose such penalties. So which means MCA on identifying such offences or violations as you call it, they can directly impose such penalty. So there is a shift from fine to penalty, and also in certain cases where there is imprisonment prescribed, the imprisonment criteria has been removed in such cases where it is filing or procedural aspects, and the penalty has been enhanced, which you will be seeing in the respective amendments. So for issue of shares at discount, for example, the company fine is 1 to 5 lakhs, whereas now the penalty is amount raised by virtue of issue of shares at a discount or rupees 5 lakhs, whichever is lower, and with a refund of interest at 12% on all such monies raised through issue. So in the case of officer in default, it will be a fine ranging from 1 to 5 lakhs or imprisonment with a maximum of 6 months or with both was the earlier provision. Now you have only the penalty being imposed, which is amount raised through issue or 5 lakhs, whichever is lower. Likewise, you have notice to registrar for alteration of share capital under 64, annual return under section 92, where earlier you had imprisonment. Now we have been doing MGT 7 only with 100 per day for each continuing day of default. And statement annexed to notice, again word punishable with fine existed. Now it is changed to liability to a penalty. So wherever the main change in these 16 offences, if you notice, is fine to penalty, and wherever it was imprisonment with fine, now the word is changed to liability with a penalty. Proxy is again punishable with fine. Now it is changed to liability to a penalty of 5,000 rupees. Again 117, all the resolutions and agreements which you file under form number MGT 14, the fine of 50,000 to 5 lakhs. Now for company and officer in default, the respective penalty and the continuing failure penalties are clearly defined. And annual general meeting reporting for listed public companies, the fine was 1 to 5 lakhs. Now it is penalty of 1 lakh, and for continuing failure, there is a penalty imposed of 500 for every day during which such default continues. Copy of the financial statement to be filed with the registrar under 137, like your MGT 7 annual return, AOC 4 also, this imprisonment word has been dropped, and they are making it now a self-governance and more to strengthen the compliance norms and for ease of doing business. And for resignation of auditor and for not giving such special notice, the auditor shall be punishable with fine of 50,000 or remuneration, whichever is lower was the earlier provision, subject to a maximum of 5 lakhs. Now you have a penalty of 50,000 or remuneration of auditor, whichever is lower. And of course, you have this continuing offense penalty of 500 for every day during which the default continues. 157, 159, again for DIN violations, where it is not being reported to registrar. 165, where the maximum limit is breached by the directors. Payment to director for loss of office in connection with transfer of undertaking. Again, the director's contravening provision, the punishment was with a fine of 25,000 to 1 lakh. Now it is a penalty of rupees 1 lakh. The last one is section 238, where there is registration of offer of schemes involving transfer of shares, where it was punishable with a fine. Now it is liable to a penalty. 197, 203, 446, again the provision of fine has been lifted, and now you have the penalty being imposed, and the specific quantum is provided in fourth column. Now we will move on to the second major amendment in Companies Amendment Act, which is CSR compliance. So this 2% of average net profit was already there in Companies Act 2013, where the minimum amount to be spent by company on CSR activities shall not exceed 2% of the average net profits. And while reckoning the average net profit, it shall not be taken for, earlier it was for at least 3 years period was there, but now there is a modification. If you read that highlighted version, for companies which have not completed 3 years since incorporation, net profit of the immediate preceding financial year shall be considered. So in which case, if the threshold norm, whatever is prescribed for turnover, net profit, everything, if it is going to reach that limit as prescribed under 135, and even for companies which are newly incorporated, if they are falling within the line prescribed, then they are required to comply with CSR norms. Now, this is the major amendment. So earlier, if the CSR amount was unspent, say 2% comes to 100 crores, and you are spending 80 crores. For the remaining unspent amount of 20 crores, the disclosure was made by all the companies in the prescribed schedule, section 135 read with schedule 7. The board's report disclosure carried the necessary CSR report containing the reason as to why such unspent amount was there and what is the intention of the management to do in the near future. So it was well covered in serial number 7 of your respective schedule. However, now after Companies Amendment Act, this norm has been tightened. So companies are obligated to spend such amount, and they are given a timeline, there are two classifications. One, if the amount earmarked for CSR activity is unspent and there is an ongoing project pursuant to the CSR policy which is approved by CSR committee and the board, such amount shall be transferred to unspent CSR account within a period of 30 days from the end of financial year, and such amount to be utilized for such project within a period of 3 financial years from the date of such transfer. And if it is not utilized, then such unspent amount shall be transferred to a fund specified in Schedule 7 within 30 days from the end of the third financial year. So this first category will apply when there is an ongoing project. In all other cases, please remember friends, the unspent amount shall be transferred to a fund specified in Schedule 7 within 6 months from the end of financial year. So this provision is inserted in the Companies Amendment Act, and there is a penalty and fine clearly specified under section 135, which is again an insertion. So what if you are going to contravene the provision? The company, there is a fine ranging from 50,000 to 25 lakhs, and for every officer in default, the same fine of 50,000 to 5 lakhs is there. Additionally, imprisonment up to a maximum of 3 years or both imprisonment and fine. So we have to wait and watch, friends, because the rules are yet to be prescribed as to what the central government is going to govern by virtue of these CSR rules. We have to see. Next amendment, third amendment, is significant beneficial ownership, section 90. So every company shall take necessary steps to identify the SBO of the company, and they shall ensure that they comply with the provisions of this section 90 subsection 4A. What it provides is, if information is not received from the individual within the time frame prescribed, or such information is not satisfactory in nature, then the company shall make an application to NCLT restricting the rights on such share of the person, and also NCLT, after giving an opportunity of being heard by virtue of principle of natural justice, they shall pass an order to restrict the rights on such shares. So what if the party is agreed? So he will have a time to make an appeal within a period of 1 year from the date of such order. And if no such application is made, then the order shall be construed as binding and it shall be transferred to the authority constituted under section 125 subsection 5, which is your IEPF of the act in such manner as may be prescribed. So we have to wait and watch the rules to be prescribed by central government for adhering to this particular section 90 subsection 4A. This is again a newly inserted provision and in NFRA. So NFRA subsection 132(1)A says that they shall perform their functions through such division as may be prescribed. So again, this is yet to be notified. So each division shall be presided over by chairperson or a full-time member authorized by the chairperson. So subsection 3B clearly says that executive body of NFRA shall also consist of a chairperson and a full-time member of such authority for efficiently discharging their functions. So the provisions of NFRA again are significantly widened, friends. If you read and compare the old vis-a-vis the new provision, earlier they were debarred. Any professional who is being proved for misconduct, the NFRA had the power to debar such member from engaging in practice. But if you read the current provision, the provision has enhanced the scope of NFRA to debar such members from performing 3 activities: 1 as auditor, 2 as an internal auditor, 3 as a valuer under section 247 of the Act. But the time period remains the same of 6 months to 10 years as may be decided by NFRA. Then we have prospectus and allotment of securities. As mentioned in the introductory slide, the shift is from registration to filing. So everywhere the word is replaced with filing to make it simple and easy to adhere. So prospectus shall not be issued to the public, signed by the director or their authorities, which has been filed with the registrar on or before the date of its publication, unless a copy of it is filed with the registrar. So corresponding change has been made in section 398, where all the documents which are required to be registered with the registrar are prescribed, where this particular prospectus is omitted. Then we have another significant change imposing the dematerialization of shares. So in 2018, we had on 10 September, there was an MCA notification prescribing unlisted companies to make it mandatory for dematerializing the shares. Now, they have again enhanced it by saying that all class of companies, as may be prescribed by central government. So we have to wait and watch if central government is going to prescribe any other class of companies over and above public companies to make their shares dematerialized under Depositories Act 1996. Third classification under this pass is section 35 subsection 2 clause C, where no person shall be liable for misstatement in prospectus due to expert's statement if such person proves that he had reason to believe that the expert was competent enough to make this and he has not withdrawn his consent before filing of the copy of the prospectus with registrar. So the change of registration to filing has taken effect in section 35 as well. Then we have section 212, investigation by SFIO, Serious Fraud Investigation Office, where they have changed the concerned officer to any officer not below the rank of assistant director. So more of substitution in nature. Again, another substitution is previously a person arrested under the section shall be taken to magistrate's court. Now they have added special court as well. And finally, there is an insertion where the report of SFIO states that fraud has taken place in a company and any officer or key managerial personnel has taken undue advantage in any form, then the central government shall apply to NCLT for ordering disgorgement of such advantage and to hold such officer or KMP personally liable. So this is an insertion, professionals. Another significant change is your registration of charges. Under section 77 of the Act, you had enough time to file your registration of charge for 30 days normal plus 270, but now you have only 60 days time, and where there is an additional delay in registering charges. So for charges created before 2nd November 2018, by virtue of second proviso inserted in this respective section 77, they have given additional grandfathering provision of 6 months from 2nd November 2018 for the old charges. For all the charges created on or after 2nd November, it is 60 days with ad valorem fee. So please remember, professionals, from 300 days, it is now shifted to 60 plus 60 days. 60 will subject to additional fees, plus 60 will be your ad valorem fees as may be prescribed by your registrar. Section 86, again, there is a significant amendment where they say that if you are going to suppress any information or provide false or incorrect information with regard to your registration of charges, then such person shall be liable for action under section 447. 447 is again of serious nature, which is your punishment for frauds. Section 87, where there is an omission to give intimation to registrar with regard to your satisfaction of charge. Omission or misstatement in two cases, under section 82 with respect to any charge, or under section 83 with regard to your memorandum of satisfaction of charge, and it is proved to be accidental or due to inadvertence or some other sufficient cause, then central government may, on application made by the company, consider that omission or misstatement to be rectified. Please, if you have any doubts, please feel free to ask me. Then we have disqualification of director, which we saw in the introductory slide, where a director is going to breach his maximum number of directorship of 20, out of which 10 is public companies, then that will also attract disqualification over and above your general disqualifications. The power of registrar is enhanced to weed out the shell companies, where companies having share capital which is incorporated on or after 2nd November, they shall not commence the business unless they give a declaration. 1, they should confirm that they have received the subscribers' money into their bank account. 2, they have to confirm that they have the registered office verified within 30 days from the date of incorporation. So these two shall happen within 180 days from the date of incorporation of the company. If a company contravenes this provision, then they shall be liable to a penalty of 50,000, and the officer shall also be liable with a penalty of 1,000 for every day during which the default continues. And similarly, if the declaration is not filed, the registrar's power is widened to remove the name from the register. The same power is now available under section 12 subsection 9, where you can verify the registered office details within 30 days from the date of incorporation, and the corresponding amendments to both the sections 10A and 12(9) for registrar to take necessary action have been suitably amended in the parent provision, which is section 248. Prevention of oppression and mismanagement, there is necessary insertion made by adding subsections 3, 4 and 5. Earlier you had 1 and 2 where a person, where he is agreed to be not acting prejudicial to the interest of the company, and he is agreed because of oppression and mismanagement, and the central government under subsection 2 had the power to make necessary inquiry. But now additional provision and additional power is given to central government where there is a sufficient cause on account of the following grounds. 1, any person is in the conduct and management of the affairs of the company is proved to be guilty of fraud, misfeasance, persistent negligence or default subsist, or the business of the company is not conducted in accordance with the sound business principles or prudent commercial practices, or company has been conducted and managed by a person which is likely to cause damage to the interest in the general interest of the industry, trade or business to which such company pertains, or the business of the company has been conducted in a fraudulent manner. In all such cases, CG now has additional powers to request NCLT to inquire the case. So every application to which such oppression or mismanagement is made by CG to NCLT, which shall contain the concise statement to this effect on the grounds prescribed, and they shall be signed and verified in the manner laid down under CPC 1908. Of course, the person against whom the case is made, he shall be joined as a respondent to this application. Section 242, again there is an amendment by virtue of section 241, where an application is initiated by central government. NCLT shall record the decisions for such officer or any other director who is proved to be guilty and in relation to the conduct and management of the affairs of the company. Section 243 of the Act, where a person is not fit and proper as decided by NCLT under 242, he shall not hold office for a period of 5 years from the date of such decision. However, the period could be reduced from 5 years if central government may, with the leave of NCLT, permit such person to do so, and he shall not be entitled to any compensation for loss of his office during this period of 5 years. And for any contravention of the above provisions, it will attract a penalty under section 243 of the Act. Petition, these are the miscellaneous provisions, friends. So petition for winding up, section 272. Earlier registrar was entitled to present a petition except under clause A and D of that section. Now, because of widening of the powers of the registrar, except under clause A of that section, registrar is entitled to present a petition for winding up in all other cases. So where you have a company, under clause A specifies about a company may by special resolution apply for winding up. In all other cases, registrar will be entitled if it has just and sufficient grounds to prove that the company is not entitled to continue, and it is better to make a petition for winding up, which also includes non-filing of your financial statements. And punishment for fraud, the penalty has been enhanced. Earlier it was 25 lakhs, now it is moved to 50 lakhs. And repeated default, there is a new penalty introduced. A company is committing the same penalty, that is a repeated default, within a period of 3 years. Then twice the penalty will be imposed, more as a deterrent measure. Section 454, adjudication of penalty. Who is an adjudicating officer? If you read under section 454, he is such an officer as prescribed by central government, not below the rank of registrar, and the jurisdiction will be as prescribed under section 454. So in such case, the penalty was earlier imposed by MCA or such other rank as prescribed by central government only for the company and officer who is in default. Now, by virtue of this Companies Amendment Act, they have made it applicable to any other person as well. And also they have included another significant amendment saying that they shall direct such company, officer in default or any other person to rectify the default wherever they consider it to be fit and proper. And if the default is made in complying with such order passed under section 454(3) or 7, then the adjudicating officer has the liberty to specify the time, penalty and imprisonment as may be imposed accordingly.